I'm Matt Nevenin, East Hillside Community Officer for the Duluth Police Department. I'm here doing a crime-free multi-housing training video for landlords. The reason we're doing this video is to provide training for landlords to fulfill the crime-free multi-housing ordinance requirements. And if you're viewing this video, you either are a landlord looking for more information or you may have received a second strike letter from the city for crime-free multi-housing. Some other resources that are available are the Office of the Attorney General, which has a website with a lot of resources and tools and information available for landlords and tenants, as well as the City of Duluth Life Safety Office, which manages rental properties, and their phone number is 218-730-4380. This should be considered informational training and not legal advice. So with that in mind, we're going to start off by explaining the crime-free multi-housing ordinance. And the reason the ordinance was made, and this is in the ordinance, is that to ensure that all residential rental units in the city are decent, safe, sanitary, and operated and maintained in a manner that avoids the creation of a nuisance in the neighborhood, an influence that fosters blight and deterioration, or creates a disincentive to neighborhood reinvestment. Property owners and managers are responsible for taking such reasonable steps as are necessary to ensure that the citizens of the city who occupy rental units may pursue the quiet enjoyment of the normal activities of life, surroundings that are safe, secure, sanitary, and free from criminal activity. One of the points of crime-free multi-housing is it's really designed to empower and educate landlords, but also to ensure that landlords are held responsible for their properties. And a lot of the resources available through crime-free multi-housing, not just the strike letters, but the best practice leases and crime-free multi-housing addendums are made for landlords to have safer, better properties. So when you read through the crime-free multi-housing ordinance, which is on the city website, it'll talk about some things. We're going to look at some definitions so everyone is clear about what the ordinance is. One of the things that's mentioned a lot is disorderly behavior. So we're going to talk about what disorderly behavior is per the ordinance. So disorderly behavior can be several different things. One is a nuisance event, and that's defined by state ordinance as controlled substance use, sale, possession, manufacture, prostitution, illegal gambling, unlicensed sale of alcoholic beverages, loud and boisterous conduct, noises and activities that disturb the peace, events between 11 p.m. and sunrise which disturb the peace and tranquility of the neighborhood, congregating a tumultuous, noisy, or rowdy crowd, fighting or obscene or inflammatory language, loud music constituting a nuisance or disturbing the peace, activities causing excessive pedestrian or vehicular traffic and parking problems and congestion, or indecent exposure or lewd conduct. That is one form of disorderly behavior. Other examples are violation of local ordinance, state statute, or federal law related to ownership, possession, or use of a firearm, illegal drug-related activity, and other miscellaneous ordinance offenses under Chapter 34 of the Duluth City Ordinance. Also, any act that jeopardizes the health, safety, and welfare of the landlord or landlord agents or other tenants or guests of other tenants is considered disorderly behavior. Any act prohibited by the smoking policy for the premises is also prohibited, or is also an example of disorderly behavior. There are exceptions for disorderly behavior. They are making an emergency telephone call to report domestic abuse and reporting domestic abuse to law enforcement, or a tenant making an emergency call seeking police or emergency assistance. Those sorts of instances should not be considered disorderly behavior and are exempt per the ordinance. There also are exemptions under state and federal law related to domestic abuse reporting. The ordinance states that crime-free multi-housing, any rental agreements for any rental unit except for residential facilities licensed by the state shall be assumed to contain the crime-free and smoking policy disclosures in them. The next thing we're talking about is licensee duties. Those are the responsibilities of the landlord or property manager. They are the responsibility of any tenant to ensure that all tenants and all guests of tenants while on or about the licensed premises are not engaged in disorderly behavior. So where the licensee comes into play is the licensee, which is of course the landlord or property manager, shall cause the commencement of an unlawful detainer or other eviction proceedings pursuant to the provisions of state law if a tenant violates the provisions of Clause C, which is going to come up next, on 3 or more occasions during a 12-month period. So this is the part of the ordinance where landlords are expected to be held accountable for what's going on their property. And Clause C is a part of the ordinance that I'm going to explain now. And the provisions of Clause C are that no tenant or guest or tenant shall engage in disorderly behavior occurring on or about the licensed premises or premise. No tenant or guest of tenant shall aid or abet disorderly behavior. No tenant or guest of a tenant shall conspire with others to engage in disorderly behavior. No tenant shall permit a guest of the tenant to engage in disorderly behavior, and any violation of the above shall constitute a material violation of the rental agreement and shall constitute good cause for the immediate termination of the rental agreement. And that is defined in the city ordinance for crime-free multi-housing. So in looking at those points, they're all essentially related to disorderly behavior occurring in the unit. A licensee shall provide to the lessees written notice of definition of disorderly behavior and maintain written acknowledgement signed by lessees. And we're going to talk about this more at the end with some best practice information. But the key is that licensees should be providing this information to the lessees before they move in and having them to maintain that they're making sure they're signing it and acknowledging they understand these rules. The licensee shall cause a criminal background check on all prospective tenants and should include all misdemeanor, gross misdemeanor, and felony convictions covering the last 3 years. This is also a part of the ordinance requiring that criminal background checks are performed by the licensee. Next, we're going to discuss revocation, suspension, declination, or denial of a license. The code official, which is the life safety office, may revoke or suspend a current rental license, deny a new rental license, or decline or renew a rental license. In buildings containing more than one rental unit, the revocation, denial, or declination may apply to one or more rental units at the discretion of the code official. There are 8 separate reasons listed in the ordinance for why a code official can take away a license. The one that we're going to talk about, which is related to the crime-free multi-housing and the disorderly behavior, is failure to commence unlawful detainer or eviction proceedings following the 3rd instance of disorderly behavior, except as provided by the postponement of enforcement. So we're going to talk now about the third notice, and we're going to go start at the beginning. So this abatement notice is what that ordinance is referring to. You also might hear it referred to as a 3rd strike or a 3-strike policy. The first notice is a disorderly event occurs at a property. The city will send a letter to the licensee notifying of the behavior. It commonly will include a police case number, the tenants involved, and a brief description of what happened. It also includes information on how to contact a community officer and supervisor if they need to discuss the issue any further. So the first notice is essentially a warning letter sent by the city to the licensee notifying them of the behavior. Upon the second notice, which is a second occurrence in the 12-month period to the same unit, a notice is sent to the licensee from the city. However, in this instance, the licensee must submit within 10 days of receiving the notice a written abatement report of all actions taken by the licensee since the first notice and actions the licensee intends to take to prevent further disorderly behavior. This is the 2nd strike. So obviously the requirement here is not just that they receive the letter, but they now have to send to the police department within 10 days, written notice of what they're planning to do to fix the problem or abate the problem. The 3rd notice, which is the 3rd or more occurrence of a disorderly event within the 12-month period, again, a notice is the licensee from the city in the form of a letter. Code officials then by ordinance, shall revoke, suspend, or reject an application to renew the license. Code officials shall make that decision within 15 days of the notice. So in this instance, they've received the 3rd strike letter. The code official now has 15 days to make the decision on whether they're going to revoke, suspend, or deny the renewal of a rental license to that unit. And as mentioned above, the revocation of the rental unit could be to the specific unit that the event is occurring or to the more than one unit at the discretion of the code official. However, the ordinance also states that no adverse license action shall be imposed where the instance of disorderly behavior occurred during a pending unlawful detainer action or other eviction proceedings or within 30 days notice given by the licensee to a tenant to vacate the rental unit, except when code officials determines that the licensee has failed to diligently pursue such process, adverse license action shall proceed. Adverse license action may be postponed or discontinued at any time if code official determines that the licensee has taken appropriate measures which will prevent further instances of disorderly behavior. So obviously at a 2nd or 3rd strike letter, if the licensee has shown that they've already begun the eviction process and it's going through the courts, they're not going to have their license revoked as long as they're making the good faith effort to rectify the problem. And determination that the rental unit has been the location of disorderly behavior shall be made by a preponderance of the evidence to support such a determination. It shall not be necessary that criminal charges be brought in order to support a determination of disorderly behavior, nor shall the fact or dismissal or acquittal of such a criminal charge operate as a bar to adverse license action under this article. So essentially what this part of the ordinance is stating is that just because someone did not receive a citation or received a citation but was acquitted or had the charge dismissed doesn't mean that that prevents the landlord from or it doesn't mean that the event can still be included as a strike. And the ordinance also brings up retaliation. No licensee or the licensee's agent shall bar or limit a tenant's right to call for police or emergency assistance in response to domestic abuse or any other conduct, or impose a penalty on a tenant for calling for police or emergency assistance in response to domestic abuse or any other conduct. A tenant may not waive, and no such licensee or licensee's agent may require the tenant to waive tenant's rights to call for police or emergency assistance. Any such waiver contained in a rental agreement shall be null and void and unenforceable. This is a fairly common sense thing, but obviously landlords cannot prevent or discourage their tenants from calling 911, from calling for police assistance to report crime, and that is outlined in that ordinance. So that kind of is a brief description of the crime-free multi-housing ordinance and how it applies to the police and the strike letter process. So now we're just going to go over some landlord advice that comes from the crime-free multi-housing organization that can help landlords have a more successful rental. One of the things that's really a key in this training for the best practices is that putting a little bit of work in on the front end with screening applicants and having good documentation of what you're doing prevents a lot of work on the back end with getting a bad tenant or having a bad rental situation. So the first thing we're going to talk about is the process of screening new prospective applicants. You should have an established process and selection criteria in writing that you're providing with applicants. The key is that you're treating everyone the same. You have the same process for everyone, and that you've documented that's your process. You should be requiring a government-issued photo ID and social security number, which you would use obviously to verify someone's identity and to conduct a criminal background check. You should be requiring the prospective tenant provide previous addresses that they have resided at and previous landlords they have had with their contact information for the last 2 years of their residences. Full names and date of birth of all the persons who will occupy the unit, and an employment history for all the applicants and prospective occupants. It is important that landlords follow the fair housing guidelines and that they treat every applicant exactly the same every time. You cannot discriminate based on sex, race, creed, disability, nationality, marital status, familial status, income, or sexual orientation. Your criteria for selecting applicants must meet fair housing regulations. However, you can be selective based on poor credit, criminal history, poor rental history, or poor references. You should require applications and information be completely filled out. And again, apply your policies to everyone and make no exceptions. You should be requiring a credit and loan references, and you should be asking prospective tenants about their criminal history, drug use, or any pending civil actions they may have had. Then verify what they tell you with background checks and checking their references to ensure that they're giving you accurate information. Ask for emergency contacts. Any personal information that you're given by prospective applicants should be kept secured. After you've gathered all this information, you should be running your credit checks, verifying any pending civil actions, as well as the criminal histories. Call previous landlords, verify their previous addresses, and check with police calls for service to those addresses they may have lived in the past. Contact their references and verify the information that's been given to you with those references. Run criminal history checks, like we have all said a few times. This is very important, and it's also very relatively easy to do. You can deny an application based on convictions. However, you cannot deny an application based on arrests. It has to be on convictions. It's also a good idea to interview all applicants in person, go over their application with them, ask them questions about it, note any suspicious responses. This allows you to get to know the applicant, but it also establishes you as a serious, strong property manager. When you deny applicants, it should be based on your policies and criteria that you've outlined from the beginning. Everything you do should be documented in writing and maintained. And spending time and money to screen applicants at the beginning of the process will save you a lot more time and money spent trying to fix a problem tenant or evict them down the road. So a little bit of work will save you a lot more work in the long run.